Welcome back to Eyewitness News, joined now by lawyer Charlie O'Hara, here to answer your legal questions. And we do have a lot of questions this morning already, Charlie. Let's go ahead. Go ahead, caller, with your question for Charlie.
My question is, what are the cops confiscated my pickup truck. They sold it at the police auction, and the case was dismissed on lack of evidence. I asked the cop about it. He said, too bad it was confiscated.
Right.
Is that right or legal?
I think I remember the details in this case, sir, if I'm not correct, is that your wife's friend had some stuff in the car. That was the reason why she was arrested in the first place, and the car was confiscated. Go ahead, Charlie.
Okay, I think we're talking about a drug seizure, from what I understand. And what happens is if you're transporting drugs in your vehicle, and they find those drugs in there and they're for sale, then they can confiscate the vehicle. Now, there's a lot that comes into effect in that, because if you don't know that the drugs are in there, for instance, in this case, it sounds like someone else was driving the car and it was someone else's drugs, not the owners of the drugs. If the owner didn't have foresight, if he didn't think that was going to happen, well, then the owner would be able to get the car back. Now, there's a procedure they go in taking your car, and what they do is they have to give you notification that they're going to try to seize your car. They can file a lawsuit to take your car. If they're successful in that lawsuit, then they can sell it. A lot of times what happens is people get a notice about taking their car. They don't want to get involved in the criminal activity, so they don't answer the notice. A default's taken, and if that happens, then the vehicle is seized. But you would have to, if you're an owner and the third party has drugs in that car, you would have to have knowledge of that. Now, that knowledge can come pretty easy. If the person's a known drug user or drug dealer and you let them use your car, well, then you're out of luck. If it's somebody that's been convicted before and you know that and you're letting them use your car, you're probably out of luck. If it's your child and you know they use drugs all the time and you let them drive it, you're probably out of luck. But if you don't know anything about that, you should be able to get the car back.
Seems like a pretty complicated situation on that one. Okay. All right, go ahead. We have another caller. Go ahead with your question for Charlie.
Yes, I was curious what their client has recourse in a case where the client has put up a sizable retainer to the law firm, and then the law firm drops the client after retainer expenses have been exceeded, and the client does not have resources to provide another retainer for another attorney. What does the client recourse have against that original attorney?
Well, actually, the short answer is probably nothing. Usually when you hire an attorney, you fill out a contract. That contract controls the relationship you have with the attorney or with that law firm. If you go through the retainer for whatever reason, doing either expenses with the attorney, or if you go through expenses with experts or things that the attorney does, then the contract probably calls for you to keep paying the attorney. And if you don't pay the attorney isn't going to work for free. And I don't think you would expect that. So if you've gone through all the retainer, then the normal thing would be to do is, if you can't afford the attorney anymore, the attorney would withdraw from the case. I don't think there's anything unusual about that. You know, most people try to keep the fees down, and if you get an attorney that tries to keep the fees down and reasonable, that's what you want.
Finally, Charlie, I'm going to ask you a question. Just coming up tonight, New Year's Eve, we don't have a ton of time to talk about this. Going to be a lot of DUIs tonight. What is the best course of action for somebody if they do get a DUI this evening?
Well, number one, you shouldn't be driving while drinking.
That is number one.
And number two, if you do get pulled over, it depends on the circumstances. They'll ask you to take certain tests and things like that. You can lose your license if you don't take those tests. Now, sometimes there's exceptions to that, but usually if you're a first-time violator, and you probably ought to take the test so you can keep your license. If you're a multiple-time violator, there's some other rules that apply, and you may want to consult an attorney about the specifics of that. But the big thing to do is don't drink and drive. Get a cab, call a friend, call anybody. Don't drink and drive. Much better to have a friend mad at you for waking them up than to get a DUI and potentially hurt somebody else.
That's right. Thank you, Charlie. Thanks for calling. You guys have a happy new year. We're back in just a minute.